be watching it later,
Yeah.
just for accessibility reasons.
I've just found my headphones, so I'm just going to put them in, okay?
Brilliant.
They were there all the time. Can you still hear me?
Yeah, can still hear
Cool.
you. Okay, I think we can get started now. So first of all, thank you so much for being here today. And thank you so much to Belinda for joining us and giving up her time for this session. It is so appreciated. Just before we get on to the point of the whole meeting, I just wanted to let you know about a couple of events coming up. So our next webinar is it's with the direct payment lead and HMRC, and I'll put the links in the chat. We've also got a roadmap for my words are going now. A roadmap for Independent Living Coalition meeting coming up, which is an open meeting, and it will be first time that the roadmap is shown to you all in full. So if anyone wants to come along to that and give feedback, please do. And then finally, our next main event is taking place on the 9th of June, which is challenging care decisions. So all the dates and information will go in the chat. But other than that, we can now get on with why we're all here. So first of all, let me pin Belinda so you can all see her properly.
Hi, everybody. Hi.
Sorry. There we go. Right. So again, thank you so much for being here. Would you mind telling us a bit about your organisation? I understand it's not a charity anymore, but a community interest company. So would you mind telling us more about that and why you started Cascaidr?
Yeah, sure. Cascaidr stands for the Centre for Adult Social Care Analysis, Information and Dispute Resolution. When we were a charity, it used to stand for Advice, Information and Dispute Resolution. But it wasn't possible for us to keep it running as a charity. After 6 years, we had to close, but we resurrected it like a phoenix and turned it into a community interest company. The reason we started it in the first place is I had been training local authorities since about 2002 in how to do adult social care as lawfully as was humanly possible, even though they didn't have much money in those days. And after 2008 and 2015, with the Care Act coming in, after knowing that austerity was going to be the way forward, frankly, I could see the way it was going and that I wouldn't be able to make a living as a trainer any longer. So I did what all good providers do. I reinvented myself and started a charity to give positive legal advice about people's public law rights in care to members of the public. And although it folded, I don't think anybody could say that a charity that managed to stay alive for 6 years, including through Brexit and COVID, was actually a failure. We had to fold in the end, not because of a lack of money so much as a lack of expertise. And that is because community care law and the rule of law and the Care Act are dying out in this country because legal aid lawyers can make more money out of the court of protection. So the reality of it is that effectively, I couldn't supervise non-legally aware, albeit very willing members of staff and volunteers to do a legal advice job that would have been something I would have been willing to sell as formal legal advice. That was my problem. But now, as a community interest company, we're running on a shoestring and we're not giving advice, but we are giving a massive amount of information and analysis so that if social services law is going to die out, it's going to have been documented to be dying out so people can see it didn't just happen by accident. That's the answer to the question, Jade.
Sorry, muted. It's chatting away to myself.
No worries.
Thank you so much for that. Would you mind telling us what services people can access through your organisation?
Are you able to put some links in the chat, Jade, as we go
Yeah,
along?
I already am, don't worry.
Okie dokie. Well, of course, we've got a website that refers to all of the services we offer, but what we've got is free services and then chargeable services. So we've got free questions and answers, which become recycled then for the general public. We've got a free database that goes back until about 2002 of legal developments and ombudsman's reports, and I do blogs and podcasts. On the other side, on the right-hand side of our website, we've got chargeable services, and that amounts to a lot of training. We do an annual course and some short courses that are very popular on direct payments, as it happens. And then we provide services in a sort of spirit of partnership and consultancy to organisations. So that will be care providers, advocacy organisations, national charities that work for a specific cohort of clients, etc. And we do have one other service that we want to provide for free called OSCAR, Online Social Care Advice About Rights. And that's what's called a conditional logic program for self-help advice resources. But at the moment, we've got insufficient funds to manage it. I would love to see somebody come forward as a philanthropist or as an IT specialist company to be able to enable us to do that and to keep it modern. We don't provide legal casework any longer. We definitely do not give advice other than for organisations. There's no way that with local authority lawyers being paid £45,000, and that's when they're quite young, there's no way that we can pay more to seduce them to jump ship and climb over to the other side. We need people with legal acumen to gut people's complex situations because I can't do it all. So the compromise is to give advice to organisations who can then pay and do a deal with the client or just pay for the client to receive the legal advice. We then use the people in the organisations to help us gut the situation and to nail the facts down. The only other thing we do in the form of legal advice is that we can get crowdfunding financial support going for some people, and we can get people to a barrister because we have got a license to instruct any member of the bar. But the trouble with that is that if people are vulnerable and chaotic and feeling traumatized by the way they've been treated, they're not in a good state to marshal their papers and their evidence. And I can't, as the professional holding the license, I can't misuse that license by foisting unprofessional instructions and a stream of consciousness on the barrister, because otherwise our license will be taken away.
Thank you very much. Do you still offer training sessions and webinars, or would you mind telling us more about the ones that you do offer, please?
Well, we train all the time. So we do an annual course in people's legal rights to care and support. And that's always been very popular. We attract about 50 people a year to that. And we also provide short course options. This year we've done charging and disability related expenditure. We've done remedies for complaints and challenges, which was my way of ensuring everybody knows about the monitoring officer. And we've also done our direct payments course. But when we offered a course about hospital discharge, there was no sign up. And at the moment, I'm providing my courses for care providers through a partner's membership site, just because I think that Cascaidr is really for members of the public. It's not for care providers. And that's really the training option at the moment. We will do training sessions for small organisations as well, if they just want a bespoke one. So yeah, I train for England as far as I'm concerned.
Brilliant, thank you. And what about your weekly alert service? Would you mind letting everyone know about that?
Well, that's the thing that we're proudest of, really, and that's the thing that we will have used to record the diminishing state of the rule of law when social services does pass into history. Our weekly alert is a sort of curated expert steer as to legal developments and ombudsman's reports that are coming out in the field of adult social care. So what we do is for £25 a year, which is about the cheapest, I think, expert information source that there is in this sector, we provide 3 or 4 reports a week, sometimes 6 or 7. We look at why they matter in a very, very short form, which comes out by email or by WhatsApp. And people who have it by WhatsApp then get a community of like-minded people to knock ideas about. And we call the one for the public and the one that would work for ILG people, we call that our peer supporters and public group. And so that's full of people, along with advocates, who care about people's legal rights. And that is the liveliest WhatsApp in terms of the debate that's going on. The worrying thing that we find with the Ombudsman's reports is that the standard has dropped off visibly in the last year. So the alert at the moment is not only telling people about what's been reported on that matters for them, but also that the Ombudsman is not the definitive source of what the law is any longer. And that's a worrying thing that I'm trying to engage with the Ombudsman about, not having any success at this moment, I have to say.
Just as an aside, I'd like to say I've been on one of your courses on DRE and it was absolutely fantastic and so helpful. And Jenny has also put in the chat how helpful she found your courses. So just for anyone who's considering them, they are well worth it. They are. You'll come away with so much information.
People do provide really inspired feedback, which of course is incredibly comforting and gratifying to me, because my particular message, I don't think it is a fashionable or a current message. It is that you have to have a brain to be able to force councils into giving you or the people you're standing up for their legal rights. That's not a fashionable message. There's a lot of waffle at the moment about the narrative. Well, my narrative is that social care is dying out and that social work is being deliberately marginalised. And of course, that's not an attractive message. So I'm really glad that the courses themselves have been good for individuals.
Yeah, absolutely. So on that note, is there anything else you'd like to tell us about your organisation?
Well, only, of course, that you're still welcome to donate, even though we're not a charity, and you're very welcome to volunteer. We've got law students who are great. They're on a revolving programme and they help out with our writing, and they write well, but they're not familiar with the community care sector, and they're not familiar as yet with the legal framework, because you can't study community care law at university. So if we're going to go the distance and last throughout the duration of the Casey Commission into reforms in adult social care, we need volunteers who are legally literate and who can take strong supervision from me, because I'm old school. And we need people who can self-manage too. Management is not my forte. So that's what we need.
Oh, brilliant. Thank you.
Should we go on to your questions now?
Well, you mentioned you wanted to talk about a topic first. Do you want to cover that now?
I'll leave that to the end, because I'd like to cover your questions, but I'd just like to tell members of your group that members of my WhatsApp have told me that they're members of the ILG as well. They can't come today, but we happen to be talking this morning about a hot topic. So if there's time for that at the end, I'll just throw that back to people. I don't have to stop dead on 3, so we'll see how we do.
Oh, brilliant. Thank you. I just wondered, because you mentioned a monitoring officer. I know it's not one of the questions, but a lot of people don't know about the monitoring officer. And I think, would you mind just explaining what that is? Because I think it's interesting.
It is really interesting. And I've even got a book on complaints, and it doesn't mention the monitoring officer. So I was staggered at that when I bought that book. The monitoring officer is a statutory paid official that exists in every local authority, not just social services ones, but in district councils as well. But in every council, there is this bod called the monitoring officer, and they are usually head of the legal department, although they do not have to be. The reason they usually are is that they are the lead governance officer. So they are accountable for holding the local authority to account, and it's an independent duty that they've got. So even though they're employed by the local authority and even though they're paid by the local authority, they have a statutory duty to which they must bring independence of thought, just like advocates do. So the duty of this monitoring officer is to keep a roving ear out for any allegation of a contravention of an enactment or rule of law. In other words, breach of the Care Act or ignoring public law principles. So anybody, literally anybody, can write in for free to the monitoring officer and set out the details of what it thinks the local authority is doing in breach of the law. And at that point, the monitoring officer has got an uncomfortable duty. They've got to consider the referral, and then they've got to come off the fence. Is the person right that there is a likely contravention? It doesn't even have to be black and white. Is there a likely contravention of a rule of law going on? And if the monitoring officer says, yep, I see that, this is a problem, they have an obligation, if they can't persuade the relevant head of service back to the path of righteousness, they have a statutory duty to go and write a written report to all elected members of the council, effectively flagging up that the council is likely to be judicially reviewed or otherwise pursued. It's like an early warning notice for the councillors, so that the councillors can then hold the head of service to account. Because the head of services policies, of course, are done in the name of the councillors. It is the council that gets judicially reviewed rather than the head of adult services. If they don't think that there's a contravention of an enactment or a rule of law, they are welcome to say so, but it's a statutory duty which in and of itself requires them to have a rational reason for their stance. And so rather than using the complaint system, we have advocated for the last 8 years that it is better to use the monitoring officer if you at least know enough law and public law principles to be able to put that down on paper. It doesn't stop you making a complaint, but the one thing that it does do, it enables you to ask the monitoring officer to put a stay of execution on anything that is about to happen, like an illegal cut to a care plan, for instance, which is not something you can achieve through the complaint system. And so it's an alternative. It's like correspondence before you even think about going to a lawyer for a pre-action protocol letter for heralding your intention to bring judicial review proceedings. And all you've got to do is to know enough law to be able to get the words down on paper. So there you go, ballistic missile, and all of their addresses are on our website. If you go on Cascaidr and you search in the search box for the words ballistic, then you will find that there's only one incident of that word on our website, and it's on the post about the monitoring officer. And halfway down, there is a spreadsheet with relatively up-to-date email addresses on that spreadsheet. So fill your boots, everybody. Kate Mercer Advocates, Kate Mercer Associates sponsored us to do that, and we were very grateful for that. That's the kind of partnership that we like.
Oh, amazing. Thank you. I've put that link in the chat for anyone who wants to see that page.
Brilliant. Brilliant.
So getting on to the questions now. So we had all these questions pre-submitted, and just to explain to everyone, we had a lot of questions. What we've done today is pick out the ones that would a lot of people would be interested in, but Belinda has very kindly answered them all. So if your question doesn't get answered today, I will email you later on with your answer, or in the next couple of days or so, just to be sure. So please don't be disappointed if yours isn't read out today. And thank you for doing that so much, Belinda. It's really appreciated.
Okay.
So
I'm afraid it's therapeutic for me, so what can I say?
Thank you. Well, it helps everyone, so
Yeah.
thank you. So the first question is, can your local authority lower your funding when your condition hasn't improved?
And when you first sent me this question, Jade, the question said, when your condition has even got worse.
Yes.
Not just hasn't improved. So I'm going to answer it both ways, okay?
Okay.
So let's take the position, first of all, where your needs have not got greater. In that situation, your situation hasn't changed, but the local authority is offering you less money. It's difficult for a local authority to do that because of the law of how they've got to take all relevant considerations into account, but it's not impossible. And that is because it's lawful to cut a care package if they can justify their professional opinion that there is a cheaper way to meet the unchanged need, or that there's a cheaper way to meet even a worsening need. And the same goes for a cut that might be said, for instance, to be over provision. If a local authority has got the guts to admit that it has over provided on a prior assessment and care plan, and in fact that it would be possible to still reduce the impact of your difficulties arising from your eligible needs, it will be possible to lower the impact to something less than significant with less money, they are allowed to do that as well. And that's because, of course, it's all public money that we pay for. Another possibility for a lawful cut is that they say the market price of care has got smaller. Although in this particular market, I can't imagine any local authority being able to say that there's an evidence basis for that. The fundamental message I want to get over is that you can end up with a cut to your care plan, even though your needs have not changed. And that staggers people when they first understand that. But that is because the cost of meeting your need may be going down, and there may be technological ways that are still going to pass muster as meeting the need, even if somebody brings judicial review proceedings against the council.
Thank you. I'm it's just some of this is frustrating, not what you're saying, but just that's the legal position. I do get what you're saying, but it just sounds like, I don't know, I think a lot of people are struggling right now with social workers justifying cuts that they don't agree with. And it's just such a difficult position to be in. Yeah.
Right. Well, what I'd like to say about that is that I'm not saying you can't do something about it.
Yeah.
I am saying that any cut to be lawful must be rationalised transparently. So if, for instance, a local authority social worker was to say one toileting visit a week will be enough, because we say it will be enough, obviously that would be something that would make your average judge choke, because a judge has got a bladder and will probably be over 65 anyway, and will know that one toileting visit is not enough. I think people think that just because something is lawful, that there's nothing that they can do about it. But the law is that the cut or the change or that any decision must be defensible in public law terms, and that the judges are there to draw the line through decisions that no reasonable authority could make. So whilst I can't say to people that they can get what they want, or that their view will be the one that is the determinant of what they get, I can say that a local authority's care manager cannot just have their arm twisted behind their back because it will be the panel's justification that is judicially reviewable. And there is therefore, that form of accountability. I hope that's cheering.
Thank you. I forgot to clarify. I have simplified some of these questions. You'll have seen what I've sent, Belinda, but just if some people send quite long backgrounds, that obviously it's just not possible to get through them all today, just so you all understand. So the next question is there a way to apply for a judicial review if you cannot find or fund legal representation?
The sad answer is no. In all of the material that I have read on the matter, the position seems to be agreed these days that unless you've got legal aid, which means having less than £3,000 to your name, which will get you full legal aid, legal representation, it would just literally be too scary in terms of the risk of having to pay the council's costs if you were to lose the case to bring judicial review proceedings. So if you've got less than £3,000, you would think, well, hey, that's loads of us. Why aren't we doing this? Well, and the answer to that is that there's a bigger difficulty at the moment, not just to being impoverished, but also in finding a legal aid lawyer who will take your Public Law Care Act judicial review case on. They're all busy doing that sexy court of protection work that I mentioned, because there is no means test for a court of protection case based on a deprivation of liberty issue. So that means that people who are incapacitated and who are deprived of their liberty in a care home or in a hospital have actually got a court of appeal to go to on free legal aid, whereas the rest of us, who may be fully cognitively impaired but fully cognitively functioning but physically disabled, etc., because they are not part of that court of protection industry and they can't use it because they are cognitively fully functioning, because they've got £4,000 to their name, they can't access anybody to hold the local authority to account. So there are notable exceptions, but it is my sad guess at the moment that legal aid and judicial review itself in community care law may well be unheard of in 5 years' time. You are able to crowdfund on public websites such as Crowd Justice, but to do that you've got to share your story, and honestly it's got to be one that matters a lot to other people. And what stops people doing that is that they feel sometimes that their loved ones' intimate, personal, sensitive data about their lifestyle, it's not right to disclose it. It's not in the person's best interests. That's up to them, of course. But other people fear being positively injuncted by the council or the ICB through the Court of Protection for even going online at all. So I would say that this is the only way forwards. You've got to be able to raise about £8,000. And if you do that, that's enough to find that a solicitor who charges privately will take on the pre-action correspondence for you that is obligatory. And if there is any success at all at that stage, any shift of position by the council or the ICB, you won't have to pay any of the costs that the other side has incurred in writing back to you. The downside is that if there is that shift of position, you will not be able to get your pre-action costs back, because there's a rule or a culture in our country that you don't get your costs back until proceedings have actually been issued. If you do go to solicitors who issue a permission application and costs are incurred at that side, those costs are part of the costs of the other side having to acknowledge service. So at that point, having been privately funded without legal aid, you are on risk as to that chunk of money and the chunk of money for the other side, unless you win the permission hearing. And even if you win the permission hearing, you don't necessarily get your costs back at that point, because the normal order is to roll the costs of the permission application up with the costs of the full hearing. So ultimately, I think that the way forwards is for everybody to be aware of a reasonably relevantly new development, and that's restitution. And restitution is claiming a sum of money from a local authority or an ICB for failing to have done what it should have done, and that has led somebody else to spending their own money or providing services. In that situation, if there is a big chunk of money back that you are logically claiming from a public body, then ultimately the prospect of winning that sum of money back ought to be enough to get private law firms of solicitors willing to give you a no-win, no-fee deal. But the trouble with those deals is, obviously, if you lose, you've still got the other side's costs to pay, so the expectation is you take out an insurance policy. And in the public law field, the insurance policy is particularly big. And so the only other option is if you are a group like the ILG or you are a charity, then in that scenario, you can get a costs capping order from the court, from the administrative court, that limits your exposure. So if you had a really strong case for a bunch of people on direct payments, for instance, you could find a barrister who would probably act pro bono for you for free, and then the publicity would get you a solicitor in all likelihood. So that's good to know, I think. What's your next question?
Do local authorities have to give answers regarding how your care hours were decided?
Can you explain a bit more what you mean about that question?
I'm assuming that this is someone who isn't happy with the hours they've been given and have asked for a justification, and the council isn't providing a justification.
So the law is, even if you find this hard to believe, councils and ICBs are required to be transparent and evidence-based and to have a rationale for their allocation of budget for the purpose of meeting your needs. And they must be aware of your participation rights, and it's difficult to be involved if they haven't given you the light switch, as it were. And this is a principle that goes back decades, but in particular, in 2010, there was a case where a judge referred to the obligation to switch the light on, not to keep people in the dark about public law decisions such as this. And the guidance is full of stuff about transparency and sufficiency as well, and basically says to local authorities, why wouldn't you give these, why wouldn't you be transparent? That's the way to obtain agreement in most cases and avoid legal challenge.
So if they're refusing to answer you, that would be grounds for a complaint?
It would be grounds for writing to the monitoring officer, because it would be an allegation of a contravention of a rule of law. And the rule of law is that they must be transparent. And that comes from natural justice and public law, but it also comes from the guidance which they are obliged to follow unless they have a very good reason not to. And not wanting to give the game away is not a very good legal reason for them not doing what the guidance says.
Thank you. Right, the next question. Can your local authority force you into a care home if you do not wish to, and this person has full capacity and has said they do not want to go into a care home?
Okay, this is a difficult one. So if you are cognitively fully loaded, capacitous, you cannot be forced into a care home without it being an assault. Because being forced into a care home means, to me, physically being taken there and not let out. That would be an assault. But you cannot both at one and the same time refuse the offer if it is made to you, and insist that the council still spends its money on caring for you in some other way. If you are refusing a lawful offer of a care home under the Care Act, and that is your choice, then in that situation, you can be abandoned, because that's what having autonomy means. Capacitated people can refuse a service. Of course, I fully accept that you might be saying that the service is not a lawful offer because it isn't suitable, or it doesn't take account of your human rights, or it doesn't take account of your wishes and feelings. But to do that, you need to know some law, and then you need to use judicial review, or the monitoring officer, or the complaint system and the ombudsman. So it all depends on what the person asking the question meant by the emotive language of forced into. People, carers and providers use the language of being forced all the time when actually they are making a choice. And here is the key. Local authorities are spending public money. They're not obliged to meet people's wish or a preference or even a demand that people be cared for under the Care Act in the setting that the person prefers. The council is the decision maker, subject to what I've already said is public law challenge about all manner of things that they can and do cock up on a daily basis, overlooking human rights, overlooking wishes and feelings, overlooking the concept of need and whether the care home can rationally meet the need, overlooking the concept of well-being, etc. You name it, they cock it up, but people do not challenge. So here's the thing about choice. Ultimately, it's likely that the council will not be prepared to walk away. If you give them a firm no to a care home, they're not likely to walk away because they are in fear of press attention. They're in fear of the coroner who says, how come that you walked away from this person? So if they don't walk away, then rather than it being the member of the public's choice, that decision not to walk away, but to toddle after the person and say, please, please let us meet your need in some other way that we can all live with, that is their choice. And if the council makes that choice, then they're still bound by the Care Act. And being bound by the Care Act means that they must offer the person the defensible, practicable cost of meeting the person's real needs in the real environment in which that person is now known to be intending to stay. And so at that point, if the budget is capped to a care home, the care home cost is not legally relevant any longer to the notion of sufficiency under public law. So in that situation, it is not possible to be forced into a care home. I hope that made sense.
Yeah, thank you. The next question is, what can you do if the local authority has made errors on your record and won't correct them?
Do you mean on an assessment or on a care plan?
I think either. I think this is an interesting one. I actually had this happen to me last year in a review. This isn't my question, by the way, but multiple assumptions were made about me by the social worker which were incorrect, and I challenged, and they wouldn't actually delete it. They would just put a note that I wasn't happy with it.
Yes. Yes. So in that situation, you're entitled to something called rectification, and it's the GDPR that gives you this right. So if you've got inaccurate personal data or incomplete personal data, you have a right to rectification. And that's because the data controller has got an obligation to ensure data accuracy. So you can ask for this to be done either orally or in writing, and the data controller has to rectify that data without undue delay, and at the latest within 1 calendar month. And they must respond to the request without delay. They can't just say talk to the hand. So if they're going to refuse an application for rectification, they've got to have a good reason for refusing, such as that it is unfounded or excessive. And if they refuse a request for rectification, they have to inform the individual of the basis for the decision and that person's right to complain, not to the local authority, but to the Information Commissioner's office. So there is that opportunity in English law to put things right in that regard.
Thank you. Okay, the next question is, do I have a legal right to know who the decision makers are in my case? So I'm assuming this is either your initial assessment or review. Probably assessment, initial.
Yes. Well, you wouldn't believe that this is the case, but yes, the answer is yes, you do. And that's because every statutory duty in the Care Act has to be somebody's responsibility. So the decision, for instance, to make an eligibility finding one way or the other, or the decision to finalise an assessment, or the decision to sign off a care plan, all of those decisions have to be some officer's responsibility under what's called the delegation scheme within a local authority. And you can write to the monitoring officer for that, or you can do a freedom of information request. And ultimately, you could even ask, for instance, about the panel's constitution and its decision-making process. Even though I've said that that's what you can do, there are decided cases where the judges have looked over their spectacles and said to the barrister, fixing the barrister with a hawk-like glare, "Can you tell me, Mr. So-and-so, who is the actual barrister, who is the actual decision maker in this case?" And in the Merton case, for instance, the barrister had to ultimately say, no, it's not possible for us to tell you. And so in that scenario, the judge got very frustrated and said, well, if I can't tell who made the decision, I can't find out their reasons, and therefore this was a decision made without reasons, and therefore it was an unlawful decision. And so on that basis, it was judicially reviewable.
Thank you. The next question is a good one, is what options are available if the Ombudsman says they cannot intervene? And I think the Ombudsman said that they can't argue with the decision, only if legal mistakes were made. However, the person feels legal mistakes were made. And this is the lady who has two daughters with the DRE, where the council are using DRE for both sisters instead of looking at them separately.
Okay, well, the sad information to provide about that one is that if one has gone to the Ombudsman, then one is very likely out of time for a judicial review. If you think about the fact that you can only go to the Ombudsman after you've made a complaint or at least aired the problem with the local authority itself, and you've got a year to do that, and you've got a year to go to the Ombudsman, the time limit for judicial review against the original decision to take the daughter's mobility component into account for the other daughter, the time limit for judicial review is 3 months only. And I'm afraid that ignorance of one's legal rights is not an excuse that the courts are interested in. Otherwise, everybody would just be saying, well, we didn't know, we didn't know. So if, in fact, that scenario has led the Ombudsman to say that the Ombudsman is either not investigating or triaging the issue out after early investigation, or saying that the Ombudsman is not able to disagree with the charging officer, then it is too late to do anything about the underlying decision. But it is not too late to judicially review the Ombudsman. And if the Ombudsman makes the most appalling error of law, then in that situation, the Ombudsman itself can be judicially reviewed. So if it's only been like a week or so since one heard back from the Ombudsman that the Ombudsman was not upholding the complaint or wasn't investigating, and the reason was that the Ombudsman thinks it's okay to use one daughter's mobility component as a means of meeting the other daughter's need, there is no way that that is legal. And that fits with my gut feeling that Ombudsman's investigators are suffering in terms of the stress that they're under. They're clearly not good enough about the law of charging. And so in that scenario, I have no doubt that the Ombudsman would go to their lawyer and their lawyer would tell them that they needed to change their mind about that.
That's really interesting, because I also heard recently from someone at Inclusion London that they are finding ombudsmen that don't always actually know the law. That it's been a recent spate of cases where they seem to be getting the law wrong. So
Yes.
it's interesting, you can challenge the ombudsman. I hadn't realised that.
Yes, yes.
So
The
that's really
polite,
interesting to know.
the polite way to do it is to say, I am reeling from my reading of your decision, and I cannot but help think that somebody has overlooked the most obvious problem with the error of law here. The error of law being a flaw in the process that would mean that this was fair and square within the Ombudsman's jurisdiction. And then to explain why the person's mobility component belongs to person A, and that therefore it cannot, in any world in which adult social care law operates, be relevant to person B. And then when you can ask them for a review if you're within a month of having received the decision, and after that you've still got 2 months for judicial review.
Oh, brilliant. Hopefully that will help the lady with the DRE issue then. Thank you. The next question, is it legal for the local authority to require people to move from a designated bank account to a virtual wallet or an all-pay card, some are referred to, if they do not want to?
Well, I have a problem with that one because I don't know the ins and outs of a virtual wallet. So what I can do is I can only answer that in terms of principle. Okay? Local authorities can offer various means of holding the money. And as we all know, a lot of them now give you a prepaid card. And I think of a virtual wallet as a bit like a prepaid card, but it might be different. It might be a bank account of a certain type that you hold in your name. I just don't know. If you've got a local authority that is moving from direct payments being delivered through a designated bank account into something that is not a designated bank account in the holder's own name, on one level, they are entitled to tell local people how the direct payment scheme will be administered. And they will have good reasons for offering a virtual wallet. They will be thinking that it is better for the person and better for them. And they should be listening to people who say, actually, it's really not. I need the human contact. If I'm anxious about something, I'm going to go into a meltdown and not press any more buttons online. I need to be led by a person because I panic when I look at a screen. And the thing to do then is to remember that local authorities are obliged to follow the government guidance. And the government guidance says that they must not offer only a prepaid card as the only method of holding a direct payment. That's unlawful. And if they're going to depart from the guidance, then they must have a good reason to make it lawful. So for me, it's perfectly possible to say, well, everyone who wanted one probably agreed to take one, and that would be a good reason. But I wonder whether they would have all agreed if, in fact, they'd been told that they couldn't only be offered that one way. And because I don't know about the virtual wallet system, I can't tell if it's just an ordinary prepaid card on a bank account that still belongs to the council, or whether it is a bank account in the person's own name. So maybe you can tell me, Jade, what do you think of as a virtual wallet?
I mean, I have a prepaid card, so I'm not entirely sure how different it is, but I think what people don't like is they've been in control of the money. They've had the bank account, they've been looking after it for say however many years. The council are then taking that money away and putting it into a third party account, whether that's a card, whether that's a wallet. There is extra scrutiny, and councils have even stepped in and stopped payments or meddled. I'm not talking about where there's been issues, but just I think there's a lot they can watch every transaction you're doing instead of you being able to control everything and then once a year having the monitoring review where you might discuss what's going on. I think that's where people are finding it frustrating.
Yes, yes, but it's public money. It's a grant, effectively, on condition that it only be used for meeting your needs.
Yeah.
So, as someone who trained social workers and who understands the social work perspective, I don't think that the scrutiny as such ought to be anything that somebody's afraid of if they're not doing anything even remotely dodgy with the money. What I worry about is the deeper legal point as to whether a prepaid card, which you use to draw money out of a bank account that is not in your name, is even a direct payment in the first place. And you may laugh at me, but I would have said that the clue is kind of in the name. Direct payments would connote a payment. Whereas being given a card that enables you to call off money from a bank account that's in the council's name doesn't strike me as actually amounting to a payment. And so I think that's why I think the government says, don't be stupid enough to make a prepaid card the only option that you are offering as a direct payment. Get people to agree to that, but not by telling them that it's the only way they can have one. Because I think the government knows that that kind of an arrangement is not necessarily enough to constitute a direct payment if you take a strict view of the legal framework.
Thank you. There are two questions left. I think both are quite simple to answer. Are you okay for me to carry on, or do you want to stop now? No.
Yep.
Okay. So the first one is, does the council need to take into account housing-related expenses, such as house service charges or my share of building insurance, when it comes to assessing finances?
So this is a question with a nuanced answer. There's no doubt about it. Local authorities are bound to disregard housing related costs in terms of the charging framework. But those housing related costs are defined in the regulations as to be mortgage and rent first and foremost. Councils are able, because all charging is discretionary, to be more generous than that. And you can ask them to articulate their reasons for saying no, for instance, to allowing for building insurance liabilities. As far as service charges are concerned, service charges attached to tenancies in supported living are usually allowed, so long as they are literally just for the housing related aspects. They mustn't be for any aspect of support or fuel or anything like that. So if there's a straightforward service charge for the building's maintenance, then I think that is something that most councils will regard as something that they must discount from your means assessment, because it's something that you can't live somewhere without paying. And I hope that's helpful.
Yeah, thank you. On that note, what about gardening, specifically where the tenancy agreement says you have to keep the garden and you're physically unable to?
I think that is either housing related costs or it's DRE.
Right.
I have seen it allowed as DRE rather than as housing costs.
Yeah. Okay, thank you. Right, last question is, can the council reject a diagnosis or recommendation simply because the medical professional was private and not through the NHS?
Well, that says a lot about the world we live in, doesn't it? It cannot do that. The implication of a stance of that nature is that the person has paid a professional to say what they wanted them to say. And I like to think that that's not always the case, and it's offensive really to the nature of the professional's integrity. Having said that, I know about private doctors who will give people drugs just because they are on their books. So I understand why local authorities are somewhat cynical about the reports that people have gone out and paid money to go and get. The key thing is that councils are obliged to take all relevant considerations into account, and this is the words that matter, to address the evidence. So if you have established the credentials of the expert, and if in particular you have shown the letter of instruction that you wrote to the expert, and that did not say, by the way, just be a mouthpiece for me and what I say about my condition. And if you've done that and then you remind the council that they've got the obligation to take account of all relevant considerations and that they must not fetter their discretion, and if you force them to address that evidence on pain of a complaint to the monitoring officer or the ombudsman, then I think that you will find that they would pretty quickly change their tune.
I think that's really interesting because especially with the way the NHS is now, not everyone can get the care and treatments or diagnosis they need. So people are having to go to private just to simply get what they should have got on the NHS in the first place. So yeah, it's an interesting point. Thank you. That was all the questions. So thank you so much.
Can I raise the one that I wanted
Please
to?
do.
Yes, it's this. Everybody who does any work to do with direct payments finds it absolutely ordinary practice that local authorities have a direct payment agreement that they require the person to sign before they hand the money over. And it's become of interest to me on the legal footing whether this is right to call it an agreement or not. Whether in fact it is a bit of paper which is really not an agreement at all, but just notification and acknowledgement by the client who signs it of the conditions on which the direct payment is granted. I take the view that the provision of the money in lieu of a personal budget is not a contractual issue at all under the Care Act. It is something that is done because the Care Act legal framework says it should be done. But the nature of the money is not a contractual handing over of budget in return for a set of promises either. It is the grant of public money which is impressed with one purpose only. And that one purpose is to spend it on meeting the needs in the way that the care plan envisaged in light of the assessed eligible unmet needs. So from my perspective, this is a document, it's a set of conditions which the council has got discretion over, but they are not terms of a contract. And I know enough law to know that there's a difference between a grant and a service level agreement. I know that, for instance, the charge for social care is not provided under any form of contract, even though people are often asked to sign their agreement to paying the social care charges. It is the provision of services under statute against the background of the legal enforcement of a charge for anyone who avails themselves of that service. That's not a contract. So we've recently got some barristers writing up some technical aspects of direct payment law as the Cascaidr legacy. We spent our last few £1,000 on identifying moot points of law and asking barristers to opine about them. And the lady in question is Ariana Kelly, and she's a woman who's written a book on charging, and she's got a technical brain, and she thinks that it is an agreement. And I think that it's not an agreement. And I have pointed out to her that the guidance talks about an agreement, but that in fact the legal regulations and the Care Act do not make any requirement of a signed contract at all. So I'd just be interested in opening it up to the floor really now and saying, what do people think?
Please do put your hands up if you'd like to speak, and I'll come to you. Anyone? You've stunned them all into silence.
Well, I'd like people to think about it, because here's the reason it matters. A lot of people in my WhatsApp are writing to me and saying that every year when the direct payment is restarted, the local authority gives them a new document to sign in which they have expanded the terms and snuck terms in or taken terms out. And because everybody thinks of it as an agreement, because it's headed an agreement, people are thinking that they are bound by what they've signed. Now, when you sign a set of grant conditions, you're merely acknowledging that you know that if you breach those conditions, your grant can be taken away. That's not the same as some of the terms that are being snuck into these agreements, along the lines of the individual who's given the budget, even if they're not the client, agrees to be personally liable for the charges. I don't think that's legal. And so I think it really matters that we expose that it's not, in fact, a document that deserves to be called an agreement. It could be called a protocol, or it could be called a set of grant conditions, and there are consequences for breaching it, but I don't think it's a contract.
It's also something the social worker can sneak things into. I had that at my last review. I was asked for records of what my PA had been doing. That I'd never been asked to do that in over 10 years. So this was a shock to me.
Yes.
The social worker said, well, it was in your agreement. Luckily, I had the agreement from over 10 years ago signed, and it certainly said no such thing, and neither did their new one anyway. So she was just completely making it up. So be careful where they try and push you. Amina, would you like to come in? I think you're on mute.
She doesn't look like she's on mute.
No, can't hear you.
Would it be possible, Jade, to save the chat? Because I can't possibly stay on long enough to answer another 38 questions, but I can see that there's been a lot of exchange in the chat. And because it's not my Zoom, I'm not able to keep it.
Yep, that's no problem. If I go to Teresa, and I'll come back to you, Amina. I'm not sure what's happening there. So, Teresa?
I was just going to say, on the point of direct payments, agreements, contracts, whatever we call them, is that they're usually so long, that you might get the sort of document that you physically have to sign, but then you're expected to have read all the terms and conditions. There's going to be a lot of people that just kind of either find that sort of level of reading kind of overwhelming, and actually I've known somebody even go back and try and ask questions about particular points in an agreement and then kind of not even really get any answers. But it's you're kind of caught in that catch-22, because if you don't sign it, you don't get your money. So it's almost like you want your care to start. For example, I suppose each time you have an agreement sent to you, particularly in the beginning, you're probably really desperate for help. So actually, until you sign it, you don't actually get service.
This puts me in mind, Teresa. I have a stepsister who's got a learning disability, and she's cared for by Buckinghamshire. And I have just done some changes in relation to the way she's cared for, etc., because I happen to be her deputy. I'm talking about the way her care is paid for. I'm her finance deputy. And I pointed out that the local authority was doing it in breach of the guidance, in the money was going around the circle the wrong way. And when I pointed this out, the social worker said that, well, thank you, she said, we can't possibly know everything about this because we're only social workers. And I nearly choked. But I'm afraid that your answer nearly makes me choke as well, because if you're going to take a direct payment agreement, either for yourself or for someone else, there is simply no option but to understand it. And I can't take people up the learning curve if they won't read. I can't make this stuff any easier than I make it. I just can't.
Yeah.
And that's the problem.
Yeah. I feel able to read and kind of understand that sort of thing, whatever. But I can't even remember. It was a long time ago. This was somebody that the person I'm thinking about that asked several questions, was somebody that was generally clued up. She worked for a local disabilities-led organisation, and I think was getting direct payments, for a family member. And I can't remember what sort of question she asked, but it was probably just stuff that the local authority weren't used to,
Yes,
being
yes.
off.
But then it's worth remembering that there's a duty to provide advice and information. And I just stand on my rights when it's my stepsister involved. I just say, well, we can't go forwards until this is done. Clearly, I need to know from the finance officer, have you in fact turned over to AI and are you all robots now?
Yeah.
So I am getting really, nearer to the end of my tether. I think Amina's microphone is working now.
Can you hear me?
Yeah, we can.
Oh, okay. First of all, hi, Belinda. Nice to see you. I did manage to join. I guess I was saying, with my limited knowledge of contract and grant law, I would tend to agree with you. It doesn't sound like a contract. But my question is, what difference does it make, given what, I'm not quite sure who was just speaking then, given that we have to sign it, we don't get a choice if we want the direct payment. So I suppose what difference does it make?
My answer to that is that if you can spot something that you think is a term in a document called an agreement, which there is no statutory basis for, and no power to hold a person to that form of a term, then that's something that the monitoring officer needs to know about.
So if it is in effect grant terms and conditions,
yes,
those should be negotiable.
They should be, because the ability to impose conditions on a direct payment appears to be a relatively open textured one in the regulations. I think it says something like such conditions as the authority deems appropriate or thinks fit. And if you were the uninitiated and you read that, you would think, well, that's open season. But in fact, the law is that it's not. And there have been cases about quashing conditions that were imposed on direct payments because the conditions themselves were unlawful. So there's everything to play for.
Thank you. Susan, would you like to come in?
Hi, I'm unmuted now. Sorry, I'm working on my phone today, so it's kind of hard. I lower my hand here as well. That's it. Yes, as regards the direct payment scheme agreement, in my recent son's review, which he couldn't tell me even if it was the annual review or just a review, she said 5 times, for good practice, I need you to sign a new direct payment scheme agreement, even though it's the same one as we signed last year. Or it's a legal document, so for good practice, we need a new one signed every year. Or for good practice, everyone is signing one. She said this like 5 different ways. And then because there is an increase in the personal budget, but that's only due to the uplift. As far as I'm concerned, people in jobs don't get a new job contract every year that they get a pay increase. So we, of course, don't have the Care Act in Northern Ireland, but I do know in the guidance on accounting and monitoring from our Department of Health way back, our paperwork is all very old, 2009, it just says, contract agreement having explained the direct payment responsibilities and processes to clients. Well, it doesn't really happen. Case managers, key workers should prepare a contract for the administration of the direct payment arrangement. However, we're now on version 3 with us in our particular trust of the direct payment scheme agreement. Our first one we got was 2015, then it was amended in about 2021 and then in 2022. And it kind of is putting responsibility and make you feel you're personally responsible for even things like redundancy. Should that arise?
Well, you are, Susan. You are responsible for redundancy should it arise.
But not personally.
Yes, because you are the employer. Because you are the employer. So that isn't a surprise to me.
Right.
So personal liability for the charges is what I was saying. You couldn't be made to take on as a holder, but personal liability, if you're somebody's authorised person, you are the employer. So ultimately, this is why every word matters and why I can't give advice about the Northern Ireland system.
Mhm.
Okay?
Well, all I did when I signed it a year ago, I didn't sign it this time. I said, I'm not refusing to sign, but I can't see where there's good practice. There's good practice in re-signing. But I signed it with a document and also in the main body of the email, giving my concerns or issues regarding that I'm signing this so as not to hold up the personal budget. However, I want for the record to be noted my concerns or, issues with this document, which had lots of things like that in it, that people, yes, but the funders of it, I know insurance only covers a little bit of redundancy, then it's up to the funders to fund the, rather than just stop the direct payments should
Yes,
that happen. But I'm going on to a different subject.
Yeah, if you are forced to make somebody redundant, then in England you will be expected to go back to the funder because it is a contingency. So my question is that my point is that if the funder tells you where to go, you are then between a rock and a hard place because you are responsible, if you are the employer, for the redundancy. And that is the bottom legal line. When you take a direct payment, you become responsible. So I've got no problems with documents that set this out well, but I've got lots of problems with documents that squeeze extra things in.
Mm-hmm.
And I think we should probably just leave it there. I just don't think it should be called an agreement. And I think it does make a difference. Jade, anything more?
No, that's everything from me. And thank you so much for staying to answer all those questions. You've been absolutely brilliant.
It's a pleasure. I'm sorry I had to do it quickly, but I don't think I would have been able to get through it if we hadn't thought about it in advance. So
absolutely.
I'm hoping that that's good. And will you please save the chat?
Yeah, I will do. And
will you send it to me? Okay, thank you. Thank you very much, everybody. Please sign up for our alert, everybody, because we need the money. We need the volume. And if people in ILG sign up, that probably keeps us going for another couple of months. So that's really worth knowing. Thank you so much. Cheers.
Thank you everyone for coming
Thank you for the opportunity. Cheers. Bye-bye.
Can I just say the best £25 ever spent per year for the alert service, Belinda, and also the courses there's some are short courses, the long course. I'm on my second time. I haven't been attending very well at the minute, but it just brings it all together, and it's very cost. It's very good value, Belinda. Thank you.
It keeps me going. Thank you. Cheers. Thank you very much indeed.
Thanks, Jane.
Bye-bye. Bye.
Thank you. Thank you, everybody.